gives a thumbs up when it is.
It tells me.
Perfect. Over to you.
Okay, thank you very much. So now I'll behave because the live streaming has begun. So we'll go over some of the significant changes to make you aware of which sections, as you're doing your own review of the document, we think it's quite important that you look at in greater detail. And then we'll provide you with some information about what the next steps are and what opportunities you'll have to provide us with your input, and ask, I guess, any questions or seek clarification from Brad or I about what's going on with the draft document, or why some of the things have been proposed that they have, if I don't cover them this evening, and then just share that input. Every bit of information that we receive from you will be shared with council and administration. Brad indicated that we would prepare at the end of the engagement period here, which will be probably about mid-September, a summary of all of the comments that we receive, with some recommendations on how to address some of those comments, especially if they include recommended changes or concerns with the draft. We'll then meet with council and have a conversation about those things and seek direction from council about what changes they may want to the draft document. I know there's a few items in the draft already that, as we were preparing for this presentation, we know we'll have to flag for council for some additional discussion anyway. So I guess the other thing I want to point out is that what we're presenting tonight too is most certainly a draft. It is not the final product, and there are opportunities to make changes to the document. And I'm assuming that there will be some additional changes or revisions required in order to ensure that it's a tool that works for your municipality. So now I'll get into it. My name is Jane, and I work for a company called Municipal Planning Services. Any of you who were involved in the engagement for the Municipal Development Plan project that the Summer Village undertook in the not too distant past may recognize me or my voice. We were also involved with the Summer Village's MDP, and we've been involved as well with the intermunicipal development plan projects that are underway or recently completed, I guess, on the north side of the lake. On the south side of the lake, it's a little trickier. We're also a consulting firm that provides planning advisory services for a number of municipalities throughout the province. In your region, we work with the summer villages around the lake and also the county of Wetaskiwin, and assist with subdivision processing. And then we're a call a friend option for your municipal administration if they have questions about complicated development or enforcement matters relating to your municipality. So we have a long relationship with your municipality and some familiarity with the planning considerations and concerns that have gone on in the community and the region over the last little while, and are presently things that all of you are looking at and trying to address moving forward. So Brad talked about our logistics, so I won't go over that. The purpose of this project that the Summer Village has been working through quite diligently through a number of very long meetings. Your councils worked really hard on this. There's been a lot of talking and a lot of thinking and a lot of debating about some of the items that we're looking at revisiting in the document over the last year in order to update your existing land use bylaw, which is not a terribly sophisticated document. It's quite simple, which in some cases is not a problem. Yours is a little too simple, I think, for the types of development pressures that you're facing. And there are some areas that it is silent on that have in the past made it a little bit difficult to implement consistently, that we were focusing on trying to identify and address and rectify in this draft. So the purpose this evening is to provide you a bit of information about what we've been doing and some information about some of the changes that are being proposed and why they're being proposed, to assist you as you go through your own review of the document. And just by way of background, and I will only have one slide here because I know that for some of you we will have talked about these things before, but there's this hierarchy of planning documents within the province. All municipalities within the province are required to have a land use bylaw and a municipal development plan. An MDP is municipal development plan. Municipalities where that have an adjacent boundary are required to have something called an intermunicipal development plan if both municipalities indicate that there's, well, if one of the municipalities indicates support for or believes there's value in undertaking that type of work. You currently have an intermunicipal development plan with your neighboring summer villages and the county. You also have your municipal development plan, which was approved in 2021, so very recent. Your land use bylaw is quite a bit older than your municipal development plan. And although it reflects the current direction in your IDP, because your IDP is doesn't have a whole lot of future land use policy guidance in it today, your land use bylaw is consistent with that IDP. And one of our objectives here was to ensure that your land use bylaw would be consistent with your new MDP in order to ensure that the municipality complies with the requirements under the legislation in the Municipal Government Act. So that's something that's guided us as we work through this project and will guide council as they have their, I guess, deliberations as we move into the approval parts of consideration of this particular bylaw. We are required to ensure that the land use bylaw is consistent with any approved intermunicipal development plan and municipal development plan. So that's one of our boxes that we need to make sure that we check. So what is the land use bylaw? Because it's a little bit different than those statutory planning documents, which are for the most part future oriented, although they do sometimes include a little bit of regulatory language, and yours do. The land use bylaw is like the toolbook or toolbox. It is mandatory for all municipalities. It establishes processes for subdivision and development, provides information about what is required to accompany an application. It also provides some of that procedural information that guides administration when they're going through the notification process about a decision or when they're undertaking enforcement if there's a non-compliance issue relating to land use, land management. And then it provides some information for members of the community in the event that you get a decision that you're not comfortable with and you want to appeal that decision. Most of the information that's the procedural information in the land use bylaw is based not loosely, it's based quite specifically on the requirements under the legislation. So it's our responsibility, and part of what we've been working on with this project is to ensure that those administrative parts of the document are consistent with the current legislative requirements. One of the planners in my office today actually was going through the number of amendments that have been approved to the Municipal Government Act over the last, I can't remember how many years it was. I think it's not very many years, like the last 5 years, and it's something like 8, which is a very high number of amendments to our piece of governing legislation. In the 10 years before that, I don't think there was one. So the Municipal Government Act has been revised significantly and in substantial ways as it relates to these types of processes that municipalities are required to administer on behalf of the province. And your land use bylaw wasn't consistent with the current requirements. So that's one of the things that we looked at in great detail in order to correct that. And it wasn't a flaw in your land use bylaw, it was just this had happened, and so this action needed to be taken to bring everything up to date. The land use bylaw establishes regulations for specific types of land uses and general types of development that occur within a municipality's boundaries. It divides the municipality into different land use districts. Often we refer to them as zones. If you have a property in Edmonton, Edmonton refers to their land use bylaw as a zoning bylaw, and districts as zones. That word doesn't exist in the legislation, but it's something that comes out of the US, and it's something that we use the term interchangeably. So when I'm talking about districts, I'm also talking about zones, if that's easier, because of where you have another property. The land use bylaw identifies permitted uses, so what types of developments are allowed by right within each district or zone, and discretionary uses. So those are types of developments that may be allowed on a lot within different districts, depending on whether or not certain regulatory requirements are satisfied. So the land use bylaw that's in effect today and will continue to be in effect as we move through this process until such time as it's repealed and replaced with a new bylaw is land use bylaw number 208. As I mentioned, it doesn't address some of those recent changes to the legislation. Many of those changes relate specifically to administrative parts of the subdivision and development process and the appeal process and that function. Also, your existing land use bylaw is not entirely consistent with the policies that are in the Summer Village's new MDP, and that's because there wasn't an MDP before when that bylaw was approved. And it one of the things that it doesn't do that your municipality through that municipal development planning process committed to doing was incorporate regulations that would help implement the Pigeon Lake Watershed Management Plan. So to incorporate watershed management best practices into your land use bylaw. And so that's one of the things that we were looking at doing to ensure consistency. And then it does also include right now some unclear regulatory direction that makes it a little bit difficult for the development officer when they're reviewing a proposed development application in relation to what the requirements are in your land use bylaw. There's a couple of areas right now where there's some conflicts, specifically in relation to things like building height and accessory buildings, where they can be located on a lot and how tall they can be. And those are things that we need to correct in this version of the document so that it's clear what's in the document. It can be interpreted consistently and it can be challenged as well. So to hold up in the event that there's a development that occurs in a manner that is inconsistent with what the municipality wanted to see happen and put into the document. So as I was going through some of the issues with the current bylaw, I think some of these maybe are additional items. There are some, your land use bylaw doesn't have a whole lot of information about the types and forms and intensities of development that you'd like to see within your municipality. And part of that is because there aren't very many definitions within the document. So one of the ways that we can provide a little bit more clarity about the things that you'd like to see happen or you'd like to develop on your lot or see happen on your neighbor's lot is to provide more definitions about what it is that we're talking about, what types of developments are desirable for your municipality and what types of things are things that you would not like to see within your municipality. I mentioned that it doesn't, your land use bylaw today, adequately address subdivision, the appeal process, and even some of the enforcement options that are available to the municipality. So those are some of the things that we have tightened up and provided some clarification about in the draft. And even the structure of the document was a little bit difficult to navigate. You know, it's simple things like it didn't have a table of contents. So it's hard to find things. So we tried to restructure the design of the document to make it easier to find information about the regulations that are included in the document. And then the last one that I did mention is that the document today doesn't incorporate recommendations from the watershed management plan. So the purpose of the review when we began this and had our conversations with council was to ensure that your municipality would have an up-to-date land use bylaw that's consistent with the requirements in the Municipal Government Act, to create a land use bylaw that as much as possible, because they are still kind of written in legalese, but is as much as possible easy to read and follow and to interpret consistently, and to make sure that the processes that administration goes through when they're going through a development application process or a subdivision process or an appeal process even, information about that is there and transparent so that you as community members know what to expect if you are yourselves involved in one of those processes. And then also to ensure that the regulations reflect the character of the community so that it's a tool that is helping you to achieve the vision for what you would like to see happen in your community moving forward. And we have some guidance about that based on the direction that was provided as we went through that municipal development plan. And the last one is to incorporate watershed planning best practices into the land use bylaw wherever appropriate in a manner that's appropriate for your community. So we're working on a number of land use bylaws around the lake on the south side right now. And one of the things that as we're going through these processes, we identified quite early on is that, you know, there's the best practice, which includes things like setback numbers and do develop areas and don't develop areas. And in communities like Summer Villages, where you are, for the most part, built out, at least the first time on your lots, the lots exist. And when we're talking about redevelopment, we're talking predominantly about redevelopment that we really need to take into consideration is, you know, what can be achieved realistically on a lot. So when we're incorporating things like best practices into this type of a document, we have to do it in such a manner that it's we're not establishing a framework that's unachievable. It would result in a bylaw that if we were to implement it as it were designed, it would make it so that you could not use and enjoy your property in a reasonable way or even redevelop on your lot. So we have to look at what your lot sizes are, what your existing built footprint is, and sort of work within that to come up with ways to incorporate some best practices to help protect the lake while still enabling you to use and enjoy your property in a reasonable way with reasonable expectations. So there's a bit of a juggle there that we've been working to achieve in order to do what we can to provide clear guidance and some better information in terms of land use regulations about how redevelopment can occur on a property without inadvertently causing harm to the lake, while still allowing development to occur within your municipality. So in terms of process and what everybody's been up to over the last little while, this started with a meeting to identify areas of focus with council and administration. And then we worked on a draft document and we presented that to council and administration and had a couple of meetings to go through that. We also sent out some newsletters as part of our engagement plan to the community and a survey. The feedback that you provided in that survey was shared with council, and we had some conversations about that as we were working through the draft and making changes to the draft. Now that council has had the opportunity to review the draft and provide us with some recommended changes to make it more appropriate and specific to your community, we reworked the document. That's the document that was just earlier this week, I believe, placed on your website. Can I confirm that the draft land use bylaw is on the Summer Villages website now? Sylvia or Brad, can you confirm that for me? So I'm not giving anybody bad information. Bradley, are you there?
It is on the website.
Okay, thank you very much. So that draft document, which is either the second or third version of the land use bylaw, is available on the Summer Villages website for you to have a look at. We're assuming tonight, as we're presenting this information to you, that you probably haven't had the opportunity to go through the document in detail, and that's okay. We've approached that with that assumption. And so we're hoping that what we'll be doing as part of this meeting this evening and this presentation is enticing you to look at it and to go through it and to identify any areas where you think we may have made a change to the document that would negatively impact your use and enjoyment of your property, or somewhere where it's, in your opinion, the regulations are unclear and some additional review and revisions are necessary in order to make the document clearer. So those are the sorts of things that we're really hoping that you will do following this meeting this evening, and then provide us with your comments so that we can share that with council. These documents are most successful when the community is involved in them. So I do really want to strongly encourage you, and I'll probably say this again before the end of the meeting, to have a look at the land use bylaw and share with us your thoughts. So where we are in the process is we're presenting the draft to you and seeking your comments and your review. And what we gather, we will share with council and provide some recommendations. And normally our process is to also share that what we heard report, including the comments we receive and our follow-up recommendations with administration to post on the website as well, so that that's released back to the community so that you can make sure that we didn't miss anything important or misinterpret anything that you shared with us. And you know what we've done with the information that you've provided. So we're, in the spirit of keeping all of this transparent and making sure that you're aware that, the time and the effort that you've put into contributing to this process, we've taken seriously, and we've done something constructive with. We will make sure that reporting back to you occurs. So that's where we are right now. This is sort of our launch of the draft to you to have a look at, so that you can share with us your feedback, and we can make adjustments to the document as required in order to make it the right document for you. Once we have those comments back and we've prepared that report and shared it with council and received their feedback, we'll prepare a revised version of the document. And then that will go back to council, and we'll get into the bylaw adoption part of this process. So The bylaw adoption part of the process is very similar for the land use bylaw to what occurred for the municipal development plan. It requires 3 readings, and after the first reading, there will be a public hearing. So if after first reading, when the updated land use bylaw is released back out to the community, there are areas with it that you still have concerns with, it will be your, I would encourage you at that time to come to the public hearing or to prepare a report to share with council at the public hearing to identify or I guess share your testimony with them directly about those areas that you think are great and those areas that you are not comfortable with. After the public hearing has closed, council will deliberate, take into consideration very carefully everything that they've heard, and either direct MPS us to make further changes to the document based on the input they've received, or move into consideration of second and third reading. Once the bylaw has received third reading, then it's adopted and it will be enacted, and that will replace the existing land use bylaw. So that is what that's sort of where we are in the process and what we have left to achieve. So I mentioned that, and this is where I start talking about the document itself. We changed the structure of the document a fair bit. I mentioned that the existing land use bylaw doesn't have the table of contents. It's written a little bit more like a legal agreement, like a contract, than it is like a standard land use bylaw. And this is one way that land use bylaws were written in the past, and we've started changing that structure a little bit to make it easier to use and to find information within the document. So the shot there on the left is what you have in your existing land use bylaw. On the right is what we've proposed in terms of new structure. It starts with definitions, provides information about the administrative functions, so who has the authority to do different, to administer different parts of the document, and then it goes through the different processes. And then it gets into the regulations themselves, and then finally has some information specifically about what is allowed in the districts. And I'm going to walk you through that in more detail as we go through this presentation. The first part of the document, in it, we've included a land acknowledgement that's consistent with the land acknowledgement in the Summer Villages Municipal Development Plan. And then we've also incorporated a guide to using the land use bylaw. So the land use bylaw is the most complicated bylaw that really any municipality has. It's the longest, and it includes a whole bunch of information about a whole bunch of different things relating to land use and land management. It's important, I guess, to note that when you are doing a development on your property, chances are you will need a development permit, and the rules for how you can develop a building on your lot, or even change grading, landscaping, are all included in the land use bylaw. And when you're looking at the land use bylaw to get some clarification about what it is that you can do and how it needs to be designed on your property, often you have to look at more than one section. So the guide just, is a gentle reminder that the land use bylaw has information in it in different sections that may apply to a single thing that you want to do on your lot. And if you have any questions or concerns about how to interpret it, that you should have a chat with administration. They're there to help you, and they know the land use bylaw, and they're, would be very happy to help you. So that's not included as part of the bylaw, but it's a sort of a Coles Notes cheat sheet to help you figure out how to use the document itself. Then the first part of the document just provides some of the bits that are, I guess, substantially the legalese component of the document. There's the title in there, information about when the bylaw comes into effect, the repeal of the old bylaws in this section, and then we've included a purpose statement that explains why the bylaw exists at all and what it's intended to do. Some of these sections have been updated. Some of them are entirely new. They're not very long sections, a sentence or two, but they're parts of the bylaw that should be included and just provide some of that administrative information to help understand the bylaw itself. The purpose of the bylaw that's been identified is to prohibit or regulate and control the use and development of land and buildings within the municipality to achieve the orderly and economic development of land, which is the purpose statement comes out of one of the responsibilities that municipalities have that's identified in the Municipal Government Act. Then the next part of the document provides definitions. So this is perhaps the section of the document that is most revised and looks different and feels different than your existing land use bylaw. In your current land use bylaw, there's 36 defined terms. In the proposed or draft land use bylaw, there's 205 definitions. And you know, even when you are a small municipality that doesn't have a whole bunch of complicated land use districts, we still need to explain how we're using the words that we use within the context of the document. Because a number of the terms that we use in a land use bylaw are used in a very special way that are pertinent to and important to the document, but are different than that they would be interpreted or used in common usage. So we think it's pretty important to provide some clarification about those terms in the definition section to make it a little bit easier to understand how the document is being interpreted by the people that are administering the document. So that would be administration or our office if it were a subdivision, and by council in the event that an amendment to the land use bylaw has been proposed or a development's been proposed in a direct control district. One of the other things that we tried to do with this section is in reviewing the definitions, provide clarity in the wording, but we also included some new graphics and diagrams to help see what the terms mean. So often when I'm doing this presentation, I'll joke that for any of the lawyers who may be with us, this is generally not something that the lawyers encourage us to do, but as people who have to explain to somebody what a lakefront lot is or what a double fronting or interior lot is, we find it so much easier to be able to point to the graphic and say, hey, this is what we mean. This is what this means. Because some of these things are a little bit complicated to explain using just words. And we want this to be a tool that is useful and clear and is something that people understand consistently. So those are some of the more substantive changes in the administrative part of the document, or the beginning part of the document. The next sections deal with authority. So it identifies the roles and responsibilities of different authorities within the municipality. And these are the different folks who approve, administer, or enforce regulations that are within the land use bylaw. So the different authorities that have power to administer or make decisions about the land use bylaw are council, your development authority or development officer in your case, the subdivision authority, and then the subdivision and development appeal board. And likely I should have put another bullet on there too that says the Land and Property Rights Tribunal, who are a different appeal board that deal with or hear appeals for some types of subdivisions and development permit applications. So this provides a bit of information about who is responsible for what and under what circumstances they're empowered to make decisions. The next section provides information about how the bylaw can be amended. So land use bylaws, just like statutory plans, like a municipal development plan or an intermunicipal development plan, are not intended to be set in stone. We anticipate that they're living documents, and from time to time, they will need to be amended or updated in order to address new development pressures that weren't contemplated when the document was approved originally, or to be adjusted in order to reflect a change that somebody would like to see in relation to a type of development they'd like to see in their lot. So from time to time, certainly in larger areas, this occurs much more often than in smaller communities, but someone will want to change their zoning or district to facilitate a different type of development than is provided for in their existing land use district. And when that occurs, they have to apply to amend the land use bylaw, and they apply through administration. The decision is made by council, and there's notification and public engagement requirements that go along with it with any of those processes. So the community is informed that someone has applied to make a change, and they're given the opportunity to share their thoughts and present their testimony to council directly in relation to what's being proposed. So none of these happen behind closed doors. There's lots of notification process and opportunities for engagement and input, but your existing land use bylaw didn't have a whole lot of information about the process and what would be required and what the administrative steps were. And we've tried to expand upon that in this document to provide more clarification. So then there's information about the development process itself. So this section provides information about what types of development does not require a permit, and there's not very many. Most types of development within your municipality require a development permit. It provides a little bit of information, I guess, to support that. In the development not requiring a permit section, there's a list of items, types of developments that would not require a permit, but there's a disclaimer that goes with that. If what you're proposing to do is inconsistent in some way with regulations that would apply to that type of development, then you would require a variance. And so then you would require a permit to get the variance to proceed with the development. So even if the thing that you want to do, for example, establish or put up a small accessory building under 110 square feet. If you wanted to put up one of those buildings, there's a maximum number of accessory buildings that you're allowed to have on your lot. And if you wanted to have more than are allowed, or you wanted your accessory building to be higher than allowed, then you would require a development permit because you would require a variance to do so, which may or may not be approved. This section provides some information about how the municipality deals with existing non-conforming buildings or uses. So sometimes people will talk about grandfathered developments. Properly, that's described as a legal non-conforming building or use, but that's what we're talking about in those instances. And this section provides some guidance about what types of non-conforming buildings or uses can be continued, and under what circumstances they can be continued, and what the triggers would be to require them to be brought into compliance. And this information is in the land use bylaw, but it comes from the legislation. This section also provides information about development permit application requirements, what is required if you are proposing to demolish a building on a lot, and when you need a permit to do a demolition and when you don't. It provides some information about how the municipality will provide notice of whether or not your development permit application is complete and what the time frame is for doing so. And then it provides information about how notice will be provided by administration about a decision issued for a development permit. One of the things that legal has advised municipalities to do over the last little while is to ensure that in their land use bylaws, they provide more detailed information about the types of conditions that may be applied when a development permit is approved. So there's a section here that's been revised that provides more detailed information about what the types of conditions might be that could be applied when a development permit is approved. So things that you have to satisfy in order for your permit to come into effect. And then the last bits there deal with the validity of permits. So when a permit is deemed to be valid or invalid, and what types of variances the municipality may consider giving and under what circumstances. And then there's some information about compliance certificates. So if you may or may not have, as you've been going through house purchasing processes, encountered a compliance certificate. Normally, when we get requests for compliance certificates, it's because somebody is selling or buying a property and they want confirmation from the municipality that what exists on the lot is consistent with what's been approved. So they want to know if it complies and they request a compliance certificate. So that's what that one is. In this section, we have identified some areas here that are entirely new. And we've identified some areas where we've made some significant revisions. So I want to flag part 5 of the land use bylaw for you, because I think that this is a section that it's important for you to be aware of, that there are significant changes, and you should have a look at that. The one that is perhaps most impactful for you would be the variance section. So I would like to encourage you to have a look at the variance section in particular, and just make sure you don't have any concerns with what's been proposed. Okay, so the next bits here deal with the subdivision process and the appeal process. Your existing land use bylaw doesn't have any information at all about the subdivision process. And there's lots of land use bylaws. Over the last couple of years, as we've been reviewing them, probably the majority of the land use bylaws that we have been reviewing don't include provisions or regulations that provide information about the subdivision process. I don't know why. It seems to be just the way it was done. Now that there is a requirement in the Municipal Government Act to identify in your land use bylaw how you will provide notice and in what form of whether or not a subdivision application has been deemed complete within 20 days of receiving the application, we have to include something. in the land use bylaws that addresses subdivision. And we figured if we're going to do that, we might as well provide some additional information that provides clarification for members of the community about what the process actually is, what it entails, what the duties are, responsibilities of the subdivision authority, so what they're required to do, and then what some of the requirements and conditions might be if you are going to subdivide your property. Now, your municipality, the only types of subdivision that we would anticipate seeing would be things like boundary adjustments. So say you and your neighbor have developed your property and you thought you knew where the pins were, but perhaps maybe you didn't exactly know exactly where the pins were, and one of your buildings is accidentally on your neighbor's property, and now one of you wants to sell and you want to rectify the encroachment issue by adjusting the boundaries of the property to get rid of the encroachment so that all of your buildings are on your proper property. That might be the type of subdivision that we would see within your municipality. I think for the most part, your raw land is built out. So there may be lots that don't have a dwelling or a cottage on them, but there isn't, a quarter section that could be further subdivided within your particular boundaries. There are some villages in that situation that would not apply to you, but subdivision could still occur. The type of subdivision that could occur would be a boundary adjustment. Okay. The appeal process, we've revised that section 2. Some of the more substantial changes that are worth noting to this section relate to changes to who hears appeals. So until Bill 48, Red Tape Reduction Act, came into effect, all development permit appeals were heard exclusively by the local subdivision and development appeal board, or local SDAB. When that change was enacted, it broadened the types of appeals that may occur within the province related to development permits. And now there are some types of development permit appeals that will be heard by the Land and Property Rights Tribunal, or the LPRT. I'm finally able to say that particular acronym. It used to be called the Municipal Government Board, and that the Municipal Government Board and 2 other boards were condensed into a new super board that is called the Land and Property Rights Tribunal, and they changed their powers. And one of the things that that board, the province, is now able to hear are some types of development appeals. They always were able to hear some types of subdivision appeals, but now there are some development appeals that go to them as well. And I think what was intended to go to the Land and Property Rights Tribunal were appeals for development where the province had an interest in either what was being proposed or had an interest in the land itself as a result of some type of infrastructure, water related matter, historic resource, or something else the province was interested in. The triggers are a little bit broader than that. I'm not sure if it was on purpose or accidental, but it's something that we need to be aware of so that we are clearly articulating with the decision what type of, which appeal board the development permit application would be heard by, so that applicants know, and adjacent landowners or anyone affected by a decision is also aware of, they know who to appeal to in the event that they would like to. So that's new. You may want to have a look at that too. There's nothing we can do about it. It is what it is, but just to make sure that you're up to speed on some of those changes, it's worth having a look at for sure. Okay, and then the next administrative piece here, and this is the last of the really boring administrative stuff. It's really, really, really important. It's super, super, super dry. But the last bit here relates to enforcement. And so what we've tried to do with this section is just to make it a little bit clearer what types of enforcement actions are available to a municipality in the event that someone has done something on their property that they either didn't have the authority to do, or they did it in a way that was inconsistent with what was approved for them to do. So this section identifies the steps that the municipality, specifically the development officer, can take to enforce the regulations of the land use bylaw or conditions of a specific permit that's been issued. It provides information about the rights of the development officer to inspect or enter a property to ensure compliance, and then it provides some information about the different types of actions that can be taken by the municipality to ensure compliance. There's only a few, ways that the municipality can ensure compliance with the land use bylaw. The options that are available to the municipality really are, warning letters, polite phone calls in the beginning. Then if that doesn't work, they have the ability to issue violation tickets, which are fines essentially, and tags. If you don't have a peace officer, I believe you can only issue a violation ticket. So only some municipalities have the authority to issue, violation tag. If you don't have a peace officer, then you can't issue a violation ticket. And then the other option, and it's really the last resort option that a municipality will use to try and compel compliance, is a stop order. And the challenge with stop orders is that normally you have to go through all of these steps first, so it takes some time. And then in order to be able to take the corrective action, if the landowner themselves or the person who's responsible for the non-compliance matter won't take the corrective action, is that the municipality has to go to court. So there's absolutely costs to the municipality and all of the community members within the municipality to deal with enforcement matters, which is unfortunate, but it is what it is. And they are not things that get resolved in a timely manner, not because the municipality doesn't care and not because the municipality doesn't want to resolve these things, but from time to time, if you have to go through all of these steps and you end up in a situation where you still have a non-compliance issue and you have to go through the stop order, then you have to go through the court process too. So there are tools available. They're slow and painful, but they absolutely do enable the municipality at the end of the day to take corrective action. So you can have a peek at this section too. We'd recommend that you do, just so that you can see how that's been adjusted. All municipalities have the same enforcement options. The only thing that differs from municipality to municipality is the fine amounts for the most part. So now we get into the bit that's a little bit more interesting, I think, the sections that deal with the regulations. So what you can and cannot do, and how development needs to be cited or designed on the law. This section, part 9 of the land use bylaw, has been revised significantly as well. So those blocks there that you can see that are yellow, those are the areas that are either entirely new sections or they're sections that have been significantly expanded. We haven't highlighted all of them for discussion tonight because there's a lot, but we have highlighted the ones that we think are really important for you to, as you're undertaking your own review, have a look at in order to make sure that you're comfortable with what we're doing, you support what we're doing and understand why we've proposed these newer regulations, and you understand how they will affect redevelopment when you go to do it on your property. So the ones I'll maybe just start going through the ones that are in the bullet on the side. Okay, accessory buildings and uses. So one of the things that we're trying to do with the document is to provide some design mitigations to enable people to build their house or cottage, to have accessory buildings, but also ensure that the way that they're sited on the property minimizes the amount of direct runoff and non-permeable surface on a lot, so that we're protecting the lake from the development that occurs in the lake shore. Most of the summer villages are located within areas that at one point would have been riparian area of the lake. So they're sensitive areas. They just are. Your community is one of the summer villages that doesn't have, except on the very south, I believe, and even a reserve parcel between the lot and the lake. You have riparian rights, most property owners who have lake frontage. And so we have to ourselves be responsible for ensuring that as we do development on our properties, we're doing it in such a way as to minimize negative impacts on the lake. Because when the lake is healthy and the lake is healthy, the fish are happy, the water is clean and not full of algae blooms, we enjoy it more, and our property values stay higher. So there's lots of direct benefit to us to just start thinking about the way we do development on the lots a little bit differently in order to maintain or even improve our use and enjoyment of our beautiful lake properties. So some of the ways we've done this are to identify a maximum lot coverage percentage. In the bylaw, there's a provision that says that accessory buildings and uses cannot exceed the maximum lot coverage percentage of how much of the lot you can put buildings on. We've included a figure that we've revised, and I'll show you that in the next slide, that talks about where accessory buildings can be located on a lot. We had lots of conversations with your council about how to deal with development in that area on lakefront lots between the dwelling and the lake, the legal bank of the lake. And you have a wonderful council. I think they're very thoughtful. They spent a lot of time thinking about how they personally use and enjoy their properties and how their neighbors use and enjoy their properties, and trying to come up with ways of, instead of just saying no to things, being creative with the design and the layout of how we do development on the lot, in order to enable people to continue to do things like have an accessory building in the lakefront part of the property and minimize the disturbance or negative impacts of that building on the lake itself. And I don't always say this about all my clients, by the way, but we had such interesting, and I think, in my opinion, innovative conversations about some of these things that I've included them in the conversations in the land use bylaws that I've had with other lake communities over the last year, because I think they're pretty cool compromises and solutions. So saying all of that, and I'll explain in a little bit greater detail what I'm talking about here, specifically in relation to special types of accessory buildings that we're calling boathouses. But this section was one of the areas in the existing land use bylaw that was most messy. There were a bunch of conflicts in the existing land use bylaw that we are still trying to work through a little bit. And I've got a little to do on the bottom of this slide, because this is one section 9.1 that I think will be revised again before we get into the approval part of this process, because I think there's still some areas that are unclear. For example, in the current draft documents, the one that's on the website that I've asked you to review, we haven't identified a maximum area for accessory buildings, so how big an accessory building can be. All that we have done right now is said that you cannot on your lot exceed a lot coverage for all of your buildings that would be greater than 40%. But in doing so and not identifying a maximum area for an accessory building specifically, you could end up with a situation where the accessory building on the lot could be bigger than the cottage. And I don't think that's what was intended. So we need to have some further discussion with council and administration about that to try and figure out how to provide greater clarification about how big accessory buildings can be, just to manage that, so we don't end up in a situation where you end up with a very small cottage and a very large accessory building, which in my opinion wouldn't be accessory because it wouldn't be subordinate to the main use on the property, which should be the cottage. So that's something that I think will be revisited before we get to the end. The other thing that I think is unclear in the existing draft document is whether or not you can have a boathouse and an accessory building, or a maximum of one building in that lakefront yard. So that's something that we need to provide greater clarification on as we move through the next round of revisions to the document too. And that's going to make a little bit more sense to you in just a moment when I get onto those next slides. Some of the areas that we have flagged specifically for you, which are changes to the land use bylaw that are regulations that don't exist in your existing land use bylaw, are policy or regulations 916 and 917, which have identified that there'll only be, it says, you can't have an accessory building on a lot that's undeveloped. So the building has to have a dwelling or a cottage on it, or you have to have an approved development permit that you're constructing before you can have an accessory building on the lot. Another thing that has changed in this section that we wanted to draw your attention to is that we've identified a maximum number of accessory buildings that you can have on a lot. So the maximum number of accessory buildings, so buildings in addition to your dwelling or cottage that you can have on your lot, has been identified as 3. So I want you to think about that number and your property, and then let us know whether or not that feels like it's appropriate, or if that's going to cause problems for you moving forward. And then we can have a further conversation with council. So this is kind of what it looks like. This is a diagram that was in your existing land use bylaw that we have revised to address the inconsistencies between the figure and the text. And then there were some inconsistencies on the diagram as well. What this diagram is intended to show, and it shows a lot of things right now, is where what the setbacks are for the main building, so your dwelling or cottage on your property, where a garage or a similar type of accessory building can be situated on the lot. So it can be in your side yard, or it can be in the front yard on a back lot. So that's the yard that faces the road, or it can be in the rear yard on a lakefront lot. So that's the side between the cottage or the house and the road. And then we've provided here for an accessory building, a boathouse or accessory building in the lakefront yard, but there are some design requirements for that accessory building that I'll talk about in a moment. And the reason we provided for or are accommodating an accessory building on the lakefront side, even though we're trying to minimize the amount of non-permeable surface on that side of the property, is because we recognize that, you need a place for the life jackets and the boats and the toys, right, that are used at the lake. And it was important in our conversations with council and administration to provide an opportunity to have a structure that you could house those things in, but to try and minimize the runoff associated with that particular structure. So this is the compromise position that's been proposed. I think it works, but we would like your feedback on that as well. This diagram also provides some information about fence height and where fences are allowed. Fences are not allowed along the lakefront property line. I don't know why anyone will put one there anyway, because it would obstruct your view of the lake, but this is just making it clear that you can't have a fence running along the lakefront property line. And then there are fence height requirements that you should be aware of too, depending on where the fence is located within the yard. So boathouses. So that is, if I go back to that slide, I don't know, you can see my mouse if I go over here, this little guy right here. We've defined a boathouse as an accessory building that's located between the legal bank of the lake and the principal building on a lakefront lot that's primarily used for the storage of watercraft and items associated with aquatic recreation. A boathouse will not include a suite, so it's not intended to be used as a guest house. It will not contain cooking, bathing, or sleeping facilities, so it's for storage of watercraft. And that's why the exception is being made, because it makes sense to have a structure in this location for the storage of watercraft and associated items. Anything else can and should be situated further back on the lot. So we've identified in the regulation section for this specific type of accessory building, then the maximum number of boathouses you can have on a lot will be one. If you want to have one, you have to have a development permit. And we need to, I think this is one of the shortcomings in the existing draft. This is for council that we need to clarify. We need to identify what the maximum size for this type of a building can be, because I don't think we've done that appropriately yet. But it doesn't need to be too big. But that's something that we need to have conversations with council and administration about. And we would like your input too, to make sure that it's big enough to be able to store the watercraft that it's intended to store. Then the design elements that are incorporated into this in order to minimize the direct runoff from the non-permeable surface are that it needs to have, and also to, I guess, to minimize the obstruction or view of the lake associated with having a building on this side of the lot, is that it has to have a low slope or flat roof to minimize view obstruction. And then it needs to have gutters on downsloping, I think there's an extra P in there, sorry. Downsloping sides with downspouts directed away from the lake that run into either a rain barrel or a rain garden. So that's why you need a development permit for this type of an accessory building, is you need to be able to demonstrate that you've met the requirements, the design requirements to enable this type of structure to be the exception that's allowed in the lakefront yard. So that's the compromise, okay? So think about that, because that is entirely new. And is intended to, while not being, a direct implementation of the watershed management plan's best practices, be a compromise position that enables people to still have some kind of a storage building for water associated activities, watercraft and the like, but minimizing potential negative impacts associated with that non-permeable surface in that very sensitive riparian area. All right, so now we have some more environmental protection regulations that are new to this land use bylaw that are intended to help implement the recommendations in the watershed management plan. So the regulations in this section, which is again entirely new, prohibit the disturbance of water courses, wetlands, or water bodies. They outline when a wetland assessment would be a requirement as part of a development or subdivision application. They outline permit requirements for shoreline modifications. They discourage non-vegetative modifications of the shoreline except for erosion protection, and they prohibit adding sand adjacent to the bed and shore of the lake. So when a shoreline modification is proposed, there's some design requirements. So you're required to incorporate revegetation and use soft landscaping elements, and that's to try and minimize the amount of runoff from that area. to incorporate low impact development strategies. And there's some really amazing tools that were prepared. I think it was a partnership between the Pigeon Lake Watershed Association and I don't know if it was LEDA. I don't remember what LEDA's group is, but I think the low impact development folks. And it's like just an absolutely wonderful guide that's available on their website that helps, gives you a whole bunch of different options that you can use. The Summer Village is not trying to tell you exactly how to do development on your lot. It's just saying, hey, when you do it, you need to be thinking about these things in a slightly different way. And then they're going to provide you with some tools so that you can choose from to help figure out what's most appropriate and will fit with your vision for how you would like to redevelop your property. And then the last bit there is to minimize the use of hard landscaping elements. So the soft landscaping elements tend to be permeable, so the water can absorb into the ground. The hard landscaping elements, the surface water runs right off of. They're non-permeable. Okay. In relation to erosion and sediment control, and this is another one of the sets of regulations that's been included in order to implement watershed management best practices. We've got a requirement now for erosion and sediment control plans to accompany a development permit application for any type of development that would significantly alter drainage on a lot. So if you're doing stripping and grading, so you're changing the contours substantially of your lot. If you're moving, depositing, or storing topsoil, aggregate fill, anything like that, so digging a new basement, then that would require an erosion and sediment control plan. Where you're applying to develop a new house or cottage, doing major landscaping that involves recontouring or those sorts of things, that's when this would be triggered. It doesn't have to be super complicated, but it does need to be something that accompanies your development permit application and says, hey, you know, this is how I'm altering the grading on my lot. This is what I'm going to do to control and manage the runoff during construction, so we don't end up with a plume in front of my property in the lake, right? Those sorts of things. And really and truly, these are things that we should have been doing for years, but we haven't. And if we don't put them into a document like a land use bylaw and share this information with people, then we won't do it necessarily. So it takes a little bit more planning to do this. It's a little bit more work with the application process, but it makes sense, you know, when you think about these sorts of things, to ensure that as we're developing on a lot, as we're going through that process, we're taking steps to ensure that we don't create, you know, an unintended drainage problem either for our neighbors or towards the lake or municipal infrastructure. Sometimes it goes back towards the road. So that's what this is intending to do, is to provide some guidance and some new requirements in order to ensure that we're addressing this particular issue and item as we're going through the construction process on our lots. So have a look at this section too, because it's new, and let us know what you think. Fences and walls. That's where we get back to that really complicated drawing again. Council, I'll throw this out to you and to you guys who are listening in. We may need to split this diagram into two diagrams because I think it's a little bit complicated. Let me know what you think about that. We can do that if it would be better if it's just got a little bit too much going on. We went with what the existing land use bylaw had and just tried to work with that, but this one kind of hurts my eyes. So if those of you out there are feeling the same way, just let us know and we can do something about it. This section provides some guidance about where and what types of fences can be developed within the municipality. Sometimes you think, well, why would anyone ever put a barbed wire fence within a summer village? And it happens. It happens more often than you think. So what we've had to do is incorporate some regulations to just clarify that, you know, within the municipality, there will be no electric or barbed wire fences because they're dangerous in smaller lots. Construction of fences, gates, and other enclosures that are greater in height than 1 meter will require a development permit. And then there's different fence height restrictions on back lots and lakefront lots. And part of that has to do with views of the lake. And part of that has to do with ensuring as much as possible that we're not building so close to the road or putting structures so high close to the road that it makes it unsafe to walk down your road. Your roads are also your pedestrian ways within your community. So we want to make sure, knowing that there are walkers and children and bikers and dogs on your roadways, that we're not setting you up to create a bit of a hazard just because we've allowed, say, too tall a fence or too large a building too close to the road and people can't see what's going on when they back out onto a property. So that's where these types of regulations come from. That's what they're motivated by. It's protecting your continued use and enjoyment of your property and your views of your beautiful lake, and then providing a little bit clearer guidance about how to deal with development close to the road too, that if we don't do properly, can be inadvertently dangerous. Section 9.9, stripping, grading, and drainage is also new. There is some regulation in your existing land use bylaw, but we've expanded it a fair bit. There are requirements now in the land use bylaw for lot grading and drainage plans. And this is something that we've been doing in municipalities, smaller municipalities, not just summer villages. This affects towns and villages too, where when the original subdivisions were registered and development occurred, there wasn't a stormwater management plan that was done at the municipality scale or at the development scale, like the subdivision scale. So the older communities. And so now we're trying to figure out retroactively how to ensure that as redevelopment occurs on a lot, it doesn't create problems for the neighbors. What's been occurring in just about every summer village, over the last probably 5-10 years, is that when an older cottage goes down and a newer cottage comes in, it's bigger, right? And a lot of the footprints or designs for the new cottages include things like walkout basements. So the lot gets built up, so it gets higher too. It's not just a larger building, but it's a higher building, and it affects how the lot drains. So because we don't have with your community information already about what the post-construction lot grading is supposed to be that is consistent with the plan for the whole area, we're having to retroactively go in and on a lot by lot basis, make sure that what we're approving doesn't inadvertently flood out the neighbor. I don't know if you've had this occur within your municipality or not, but just about every municipality has. So if we put these provisions in, we're able to say, hey, at time of redevelopment, you need to tell us what your plan is for recontouring your property so that we can make sure that what you're proposing for the post-construction lot grading and drainage plan is going to work. It isn't going to create a problem for municipal infrastructure. It's not going to create a problem for your neighbor and everybody, and it's not going to create a problem for you. So all of those things. If we don't ask for the information and there's a problem, then the municipality can't take enforcement action. So is it more work for the applicant? 100%. But if we don't do it, then we can't ensure compliance down the road and take corrective steps to address the issue. The only way we can do it is everybody goes out and stares at it and is like, well, doesn't look like it drains the way we thought it was going to drain. And then you have to get surveyors in, and it gets expensive and messy and creates a really big fight. So if we just do this properly before development occurs on the lot, we're able to get in front of and address a whole bunch of the issues that over the last 5-10 years have been presenting in older communities. So that's where this stuff is coming from. I want to make sure that you understand why we're doing these things. It's because we've identified an issue and we need to come up with a solution that isn't, a master stormwater management plan for the entire summer village. It's something that we can do a little bit at a time, as cost effectively as possible to minimize potential negative impacts that occur at time of redevelopment. So look at this section 2. And then landscaping. So one of the ways that we minimize the amount of surface water runoff that we're seeing on lots is to require landscaping. Landscaping, if it's done properly, is excellent, is an excellent helper for us to controlling surface water runoff. And then also ensuring that the water that leaves the lot has been filtered a little bit, and we've been able to manage not only the quantity, but the quality of the runoff that's entering the lake. So, there's all sorts of other things that landscaping also provides benefit for, but just in terms of implementing watershed management best practices, this is a real biggie and really an important one too. So there's a requirement now when you're doing a redevelopment that would require removal of a bunch of vegetation to provide a landscaping plan with information about how you're going to landscape the lot once the development is done. So have a peek at that one. One of the things that we've done is try to establish in a relatively clear way what the requirements will be, with still providing individual landowners the flexibility to create, you know, the landscaping plan of your dreams. In the landscaping requirements section, we've identified a maximum percentage of the lot that can be covered in buildings. In addition to that, we've got a maximum percentage of the lot that can be covered in non-permeable surfaces. And for the most part, this is your driveway area, depending on how you do the driveway. And then there's a requirement for a minimum percentage of the lot to be maintained in vegetation, including trees and shrubs. And the reason there's a requirement for some trees and shrubs in this vegetation percentage is that if we don't, then we could run into a situation where the only vegetation provided is grass. And that grass is just not a great helper with encouraging infiltration of surface water and doing the filtration that we'd like it to do before the water enters the lake. The trees and shrubs are much more helpful, especially when they're native, because they have a different root base that is that changes their ability. It makes them act as better sponges. So all of these things are pretty deliberate. There was a lot of care put into these recommendations, and even though they are quite prescriptive for what we're used to, there's a reason for this, and it should help to ensure the water quality of your lake, and it help to ensure your continued use and enjoyment of the lake and the property, the value of your property. So it's a little bit of additional pain, because again, it's a little bit more work that you have to do when you're going through your site planning process for redevelopment, but it's good work. It's a good work that should help ensure that moving forward, you can enjoy your lake property for, you know, generations to come. So have a look at this one too, because it is certainly a change to what we had before, but the commitment to implement these types of design mitigations and regulations comes from what's in your approved municipal development plan. And we're hoping we've created enough flexibility in these provisions to ensure that we're enabling you the flexibility to design your property, you know, in a way that fulfills what your dream is for your property, and still minimizing those negative impacts that could occur if we don't have any guidance or regulations to address these things at all. So the next things that we have some changes to the regulations affecting would be recreational vehicles. So you do, in your existing land use bylaw, have some regulations that relate specifically to RVs. There are some changes proposed. Right now in the land use bylaw, it says that an RV may be used on a lot where a development permit has been issued for a home under construction for up to 24 months. It's been proposed to reduce that time frame from 24 months to 12 months. So have a look at that and let us know if you have any concerns. The next one relates to how long you can have a development permit for an RV on your lot for. You guys, currently it says you can have a development permit for an RV, or you have to have a development permit for an RV if that RV is not the one that you're just storing on your property. It's one that people are going to stay in as guests whenever they're going to stay for longer than 3 days. But there wasn't an upper threshold, so it was a little confusing for what that period could be. So we've just established an upper threshold. So for whenever you're going to have a guest in an RV for more than 3 days, you need a development permit, and that period or duration cannot exceed 14 days. There is another provision that's been added that says with 2 weeks notice, the development authority can issue an additional permit for an additional RV that would allow you to have, you know, more than just the one that you currently can today. So this has been expanded a bit for a special event. So that should provide a little bit more flexibility. You know, if you've got 2 kids that are coming at the same time and you have room on your lot because you have to not be in the ditch or that sort of thing, or you've got a wedding or something like that going on, there is a little bit more flexibility in this section than there was before. And the other change there just relates to disposal of gray water for the most part and wastewater. So in the existing land use bylaw, it said that development permits, so the application must include information about how you're going to dispose of wastewater associated with an RV. It's been clarified to say that how the wastewater is disposed of associated with the RV must be consistent with the municipality's wastewater bylaw, and it cannot be disposed of onto the ground, not even the gray water. So that's the more substantial changes to this section that I wanted to flag for you as you go through your review. 9.22 deals with guest house suites. So as a reminder, in your existing land use bylaw, you're allowed to have a guest house suite. Your definition of guest house suite does not include buildings that have cooking facilities. So a guest house suite currently and continues to be defined as a permanent accessory building which has sleeping accommodation and may have a bathroom but does not have cooking facilities and is not intended to be used as a self-contained dwelling but provides overflow accommodation for the main dwelling on the lot. So I want you to think about that one too, and provide us with your feedback about that particular definition. You are not today within the Summer Village allowed to have a suite that has a kitchen in it, a cooking facility, and we've carried that forward in the draft. We have clarified in this section that you can only have one guest house suite, so you can't have 3 different buildings that all provide sleeping accommodation separate from your cottage or house. There's a maximum of 1. So think about that one too, and that you can't use a manufactured home or RV as your guest house. So they're considered a different type of use and regulated in a different way. The guest house suite can't be located in the front yard of a lot. So if you're on a back lot, it has to be set behind the cottage. If you are on a lakefront lot, it has to be on the roadside. And it cannot be located above a garage, so on the 2nd story of a garage. So the maximum height for a guest house suite is a single story. And we had a lot of conversation about this too with council and administration, and the concern with allowing a guest house to be the 2nd story of a garage is that it would have an impact on views of the lake. And this is something that council weighted quite heavily as we had these conversations. So I would like you to think about that one as well and provide us with your input on that too. The RV section, the guest house section, they tend to be the ones where we receive the most feedback from members of the community. So I want to, really draw your attention to these sections to make sure that you're comfortable with them moving forward. Tree removal. So even though I think your existing land use bylaw discourages the removal of trees and vegetation, there aren't requirements. And because we haven't in the past had a requirement for landscaping plans, even if trees are removed, it's really difficult for the municipality to do anything about it. So the inclusion of this section is to provide a little bit more clarification and to require development permits for the removal of trees when they're healthy trees, and they don't need to come down as part of a development permit application for a new house or something like that. Like if you're applying to redevelop a lot, then you would be dealing with the tree removal as part of the development permit for the garage or the house or whatever it is that you're putting on the lot. But if the trees are just coming down, then you need to apply for development permit to do that. So everybody sort of knows what's going on. And there is a requirement to replace the healthy trees. There are lots of situations where a tree has to come down. My neighbor in the city just brought down almost every single tree on his property next door. And I don't think it was because he doesn't like trees. I think it was because the trees were not well. They just sort of reached that age in their life cycle in the city where they were either falling towards his house or the big spruce was dead in the front of his house. So in those sorts of situations, it is what it is. The trees have to come down. But we're trying to protect with this section the healthy trees and to ensure that if a tree has to come down, because from time to time a healthy tree has to come down to facilitate redevelopment, that tree is replaced. So that's where this one is going, to try to ensure that you don't run into a situation where as redevelopment is occurring, all of the trees in your municipality disappear, because it's easier to clear the lot than to work with the trees, right? In some instances, this is being a little bit more mindful or thoughtful about how you're doing development on the lot to try and protect some of the healthy trees, and then to where you can't ensure replacement. Okay, that's the really heavy stuff. So I did the really boring stuff, and then I did the really heavy stuff, and now we're just going to have a little bit of a discussion about the mapping and the districts. And this is not as heavy, so we get to end on a little bit of a lighter note. With the land use bylaw map, we made very few changes, so we just tried to make the map a lot more readable. The version on the left is your existing land use bylaw map, which I find really hard to read with that yellow. The new one is exactly the same, except you'll notice that there is a little red rectangle. That's the property, and when you turn into the Summer Village on the left side of the road, I feel like it was formerly a gas station at one point. And so we know there is, that's a site with some history. that moving forward, we just need a marker in the planning document somewhere to remind us that if and when that site redevelops, that one might need a little bit more information in support of the application. And so we put that particular lot into a direct control district. It is the only lot within your municipality that's within a direct control district. And the significance of it being within a direct control district means that when a development permit application is applied for, instead of the decision being issued by the development authority, the decision will be issued by council. And it also changes the appeal right. That's just sort of something that accompanies a direct control district, is that if the decision is made by council, the decision is not appealable. But the intention here was not to limit appeal rights. The intention here was to ensure that there's a marker in the land use bylaw that this is a particular and unique site, and what's allowed on it in the future will depend on what's going on under the ground. So it will require a little bit of further investigation. So that's why that one was done a little differently. But that is the only significant change to the mapping. In the establishment of the district section, we just provided a little bit of a clarification about how the boundaries are to be interpreted. And then we updated the districts themselves to provide more clarification and get rid of the conflicts between the building height regulations in the districts themselves. And in the residential district, there was two provisions, one after the other, that indicated different maximum building heights. I don't know if a word was missing or what happened, but it made it very difficult to figure out what the maximum height of an accessory building was intended to be. So we've tried to address that and get rid of the inconsistency and make sure that it's consistent with that other figure that I showed you earlier. And then we've made some minor adjustments to the permitted and discretionary uses just to be consistent with what the definitions are in the document. In these sections, some of the regulations were removed, and it wasn't because they weren't valuable, it was because they were in the wrong spot. And so they haven't been deleted from the land use bylaw entirely, they've just been reorganized into the more appropriate sections. So they're either now in the general or specific regulation sections. At the end of the district, there is another figure that's unique to your land use bylaw that we've remade. In order to provide better clarification about what the set side yard or front yard, rear yard setback requirements are, not side yard, excuse me, for different buildings of different heights. So in your municipality, the maximum or the minimum required setback from a rear yard or rear lot line or front lot line depends on how tall the building is. And your dwellings in your municipality can be between 1 and 2 stories. So where the dwelling is 1 or 1.5 stories, the setback requirements are 6 meters from the rear yard on a back lot and 6 meters on the rear yard on a lakefront lot, and 8 meters from the front yard, front line on the back lot, and the same requirement for the lakefront lot. For a 2-story building, it's 10 meters and 10 meters. So it's a bit different. And recognizing that, you know, there are different types of buildings. Some 2-story buildings are maybe, you know, they're not rectangles, they're different shaped. The measurements, it identifies where the measurements will be taken from on the building here too. So this is written in the district, and then it's illustrated on this particular drawing. So hopefully that makes it clearer. Let us know if you have any concerns with that diagram. Park district, we just added some new uses that were included in the definition for clarity. We did not change provisions relating to storage of watercraft or RVs. You are not allowed to store watercraft or RVs or anything within the park district. That's the green areas on the map. Boat lift storage is allowed with a tag from October 15th to June 15th, so that remained. The direct control district is new, and it's just for that little red rectangle that I was talking to you about, and I explained the purpose of that. The types of uses that will be allowed in that district will be at the discretion of council, and really it'll depend on what's proposed and what, when the information is submitted, is deemed to be appropriate on that lot. just to address the legacy historic use on that particular property. And we don't know enough about it. We don't know that it's contaminated. We don't know that it's not contaminated, but we just need to make sure that there's a marker. So that's your entire land use bylaw in what, an hour and 40 minutes. Clearly that is not your entire land use bylaw in an hour and 40 minutes. I've tried to give you a pretty high level overview of some of the more significant changes. It's really, really, really important for you and for council that you have a look at the document. We'll post the PowerPoint on the Summer Villages website too, so you don't have to listen to an hour and 40 minutes of me. If there was something important that you wanted to go back to, you can just have a peek at the PowerPoint presentation, and hopefully that will flag your memory and help you as you're going through that review too. But we will post this entire presentation as well, so that it is available. Please, if you can, for us, let your neighbors know that this is available for them, and encourage them to, at minimum, have a look at the bylaw, the draft bylaw that's on the Summer Villages website. And if they have specific questions that you think we may have answered in this presentation, encourage them to watch it on YouTube. I think they can put me on fast forward. So if they need to, they can do that. They don't have to spend an hour and 40 minutes. But I hope this has been valuable for you. Now that we're at the end of the part that is me talking at you, Brad has just indicated to me that he has received a couple of questions. So I'll turn it over to Brad, and between the two of us, hopefully we can provide you with some answers. You'll notice on this slide too that if you're still thinking through your questions, that's okay too. Another planner that works for our office, she's lovely. Her name is Rose. I've put her email address here up on the screen for you. And please do feel free to contact Rose with any questions or comments that you might have. And either Rose or I or Brad will contact you and follow up with you as well. So, all right, Bradley, I'll stop talking and I'll let you convey some questions for us, and hopefully we can work through those.
Excellent. I would also recommend that if you're going to check it out on YouTube later, you switch your playback speed to be much faster so you can get through it quicker. And Jane also sounds like a chipmunk at the same time. We had two things come in at this point. One was a note from Mayor Ian, just noting that there may be a few laneways and other properties that would be more appropriately districted in the Parks District or perhaps something similar. So that's more just a note for us to consider. I think that's a carryover from your current land use bylaw and its land use district map, which kind of blanketed a zoning of residential on most properties. So we'll take a peek with that and work with council to identify where those properties would be. They would not be anything that would be privately owned. Again, there'll probably be more road right-of-ways that are not developed or other reserve parcels that might have been missed. The other comment that was brought up was regarding removing fines from the land use bylaw. Jane, I can't quite remember if you got into the exact details of why the dollar amounts would be removed from the land use bylaw and put into another one. Do you want to speak on that?
I didn't mention that at all. So whoever brought that up, thank you very much. So what we've been doing with the land use bylaws is we've just been removing those monetary value pieces from the land use bylaw itself and having the municipalities put them into a fees and charges bylaw. And that's something that is more regularly looked at and updated by the municipality, and as it should be. This is what our development permit fees are. This is what our fees are if we issue a tag or ticket. This is what the fee is if you request a hard copy of the land use bylaw, like all of those sorts of things. And the reason we do that is just because we don't anticipate in large part that your land use bylaw will be looked at regularly. Other than to use, it should be looked at all the time. But once this is done, the land use bylaws normally are not reviewed at this level of detail more than once every 10 years, unless something dramatic changes, right? If there is a whole bunch of additional tinkering to the Municipal Government Act, then you may have to come back and revise it. But even if you did that, it would be a focused or targeted type of amendment and review to address those things. So it just separates those things that we think should be in a fees and charges bylaw all into the same place. So you're all looking in the same place for all of those things, and then gets it out of the land use bylaw. So that was the intention there. It also, for everybody's information, makes it easier to change. So if you amend your land use bylaw, you do have to provide notice to the whole community that this is something that you're looking at doing. You have to have 3 readings, and before the 3rd reading, often it's done after the 2nd reading, you have a public hearing, right? So it's quite complicated to amend the land use bylaw. The fees and charges bylaw can be amended at a council meeting. In one sitting. They could potentially do three readings in one sitting. So it does make it easier to change. So that's something to be aware of, but it is the more appropriate place for it to be. Any other ones, Brad?
I've not received any. If anyone does, please send them along to me, or I believe there's a hand raise function if you prefer to use to kind of ask a question verbally, if that's more convenient, depending on your situation. But maybe we'll just give everyone just another minute here to stew it over. And again, if there are questions that come in later to Rose, myself, or Jane, we'd be happy to answer via email and collect that for our report for council.
We did not intend to put you on the spot tonight. I knew I would be doing a lot of what we give my son a hard time for doing, data dumping. There'd be a lot of me talking at you tonight, just to give you some information and some background about what we've been working on. So I really appreciate that you've taken the time to join us for this and to listen in and get some information. And we were happy to chat with you, over the next 3 weeks, whenever you would like to address any questions or concerns that you might have. So seeing no other questions, maybe we will end the recording and we can end the presentation as well. And I will free you 6:15, and you still got a nice portion of the evening to enjoy, those of you who are at the lake, and I hope that you do. And we look forward to hearing from you hopefully soon. Oh, yeah. So I'm going to mention that the feedback deadline that we've identified there is September 9th. So please share that information with your friends too and your neighbors, so that we can get that information back and compiled into a report that we'll share with council and post on the website, and make any changes that we need to. I know that ideally the time frame for completing this project, what we've been talking to council about is looking at first reading before the beginning of December. So October, November, ideally October, but we'll see how that goes. And then scheduling a public hearing. It will likely be virtual like this, recognizing what time of year it is for all of you. In January, with consideration of second and third reading, either at that meeting or at a meeting after that time, depending on what occurs at the public hearing. So we'd like to be done by end of January, end of February, so that we're ready to go for next construction season. Okay. Oh, all right. So that's it for me. Ian, did you want to say anything?
Just very quickly. I know it's Darren and Susan are there, and Annalie was there earlier. Just a few people attended, but hopefully you found the information useful. Please talk with your neighbors and review that. I'll send out an email to the community, just basically asking for people to review it. There are some significant changes, so if you have anything, feel free to talk with anyone, or just forward the feedback, and we'll discuss it as a council. We want it to be reasonable what we're doing, so we think we've achieved it, but as with something so significant, I'm sure there's mistakes that we have made, and we're trying to minimize those for sure. So it's been a really good process for us to go through. So thanks for attending, and have a great night, and thank you, Jane and Brad, for hosting.
Ian, I forgot that at the beginning of this you had indicated that someone had given you a comment.
Yeah, I think what I'll do with them, I mean, basically they covered a lot of what you said. They're basically saying, water sources need to be protected, setbacks for garage, using the pins as opposed to the road, which we've done. What are the rules regarding retaining walls and so on. So I think what I'll do is I'll get back to this person and just say, a lot of that or all of it is included in the new bylaw. So from what I can see from the commentary here, and just ask them to review it and see if it addresses their concerns. Their main concern is around vegetation removal and creation of concrete retaining walls and so forth on the lakefront, and what we can do to try and minimize that impact. So I think I can probably deal with that, Jane. There's nothing really new, and I think we've seen what we have. So thanks for asking.
Yeah, no problem. And if you think any of that, there's other people in the community that maybe didn't send along comments but have similar questions. Maybe if you forward that along to us, I'll include it in the What We Heard report, and then we can include the response publicly in what we put together in that too.
Okay. Yep.
Okay, thank you. All right, then I think that concludes our engagement session for this evening. So thanks again to those of you who stuck it out to the end. Poor council's heard me go through this so many times. You guys are troopers.
Yeah. Have a good night, everyone.
Good night, everyone.